Hi, I'm Hank BREENAN, and I approve this message.
I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
Hello, and welcome to Alexa's Room, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people who have opinions about all things going on in the true crime community, including the Karen Reed hearing that went down yonder today. And be still my beating heart, we actually got some rulings in from our favorite canola oil, Beverly. Oh, Beverly, you did not disappoint. I was so surprised. She said Monday we should expect to hear from her. So I took that literally, but she did not disappoint. She came in with her little cute postscript note. So, I guess she was serious about sticking to that April 1st start date, which I think is kind of ironic because somebody brought up a good point. We haven't heard from the SJC yet, so how are we gonna kick this thing off if we haven't even heard what charges she's going to be prosecuted with? How does that work? I don't know. So we have a lot to talk about, but this clip was probably the highlight of the day. This was following the little back and forth about Rick Grain Batch, his affidavit, revised affidavit, completely exposing Jen McCabe for the liar that we have known for more than a year at this point, that she is about that 2:27:40 a.m. Google search House Long to Die in Cold. And Hank the Tank BREENAN, I should refer to him as now, because apparently he can't spell his own name. He's got a little trouble in that area. I get it. Sometimes I'm a little dyslexic myself. He mixed up not only bits and bytes, but now he's mixing up hashtags and hash values. Maybe he's searching his name too much on the Twitter axis. I have no idea, but I thought this was absolutely hilarious. And shout out to True Crime Girl on Twitter for sharing for us to all giggle and enjoy this Friday Eve.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
It is, because the hashtag is the thing you use to go trending. Although you don't, according to Elon Musk, you don't need a hashtag on Twitter. So that is a thing. But back in the day when social media was becoming a thing, and influencers were becoming a thing, and where you could actually make a living from just posting about your life as a vlogger or whatever on Instagram, and you would need the hashtags, and everybody had a million hashtags in their caption. That's what a hashtag is so that you trend. A hash value still completely goes over my brain, but to my basic Neanderthal understanding, it has something to do with the state of the data that is being retrieved from said thing that you are. I'm not going to explain this the right way, but it's important. It's important, and it was not included in the initial transferring of evidence to the defense. So that is why it is a big deal. It essentially proves whether or not something was manipulated or not. So that's the short tea of it. But I thought that was absolutely hilarious, and it even made David Gannetti smile. I mean, let's all just get us somebody who can smile at us just like that handsome devil. All right, so now on to the actual news of today. So we heard again from Gretchen Voss's attorney, Gretchen Voss being the journalist from Boston Magazine, that 2023 Boston Magazine that she wrote up about Karen Reed. Last month, we heard from her attorney and as well from Hank BREENAN about how the Commonwealth wanted to get their grubby little meatball hands on the notes that she had taken, which has definitely sparked a very interesting conversation, being who Gretchen Voss is and now who she's allegedly besties with, which is pretty interesting as well too. So and this was one that we actually got a ruling on. So I want to go over just a little bit about what was spoken about today. So this is from NBC 10 Boston. So, and I love this. They say a judge. By a judge, you mean the judge. The only judge who is allowed to reside over this case, the Honorable Beverly Canola Oil, in December granted prosecutors Hank the Tank BREENAN his request for access to off-the-record interviews, notes, and other documents involving conversations that Reed had with Boston Magazine reporter Gretchen Voss, aka Jen McCabe's new bestie. In Friday's hearing, Voss's attorney petition for reconsideration of that material, arguing its release impairs the ability to accurately report on news and that it has wider implications for the First Amendment protections of the media. And again, the irony, and it just reeks of Jen McCabe. It really does, especially when you hear what exactly was argued and the exact words and language her attorney used to argue this today in court. Requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. I mean, Karen Reed even said, like, I don't give a flying duck. Like, release the hounds. Like, put it all out there, which is a lot like the Justin Baldoni, Blake Lively stuff right now, right? So that we just did a video on yesterday. Team Justin's all like, just let's make a website, like, and just leak everything because I have nothing to hide. And I feel like if she did have something to hide, she wouldn't be going out to Julie Miller and saying, yeah, you can live with me for, 48 hours to 72 hours in the house where I literally was arrested, where me and my boyfriend used to hang. Like, it makes absolutely no sense why she would put herself in all of these vulnerable situations. Plenty of places with plenty of spotlights, plenty of people, her supporters, recording her all the time. Like, this girl is always on camera. Like, she is not afraid. Release the hounds. But that is why the defense didn't argue against this, because they don't care. Now, that being said, I have a problem with it because of the fact that, yeah, it does not protect the media. And I think that there needs to be more laws, better laws in Massachusetts to protect the media so that they can protect their sources. Because now, if anybody in Massachusetts is going to get chased down for a story, they're not going to be willing to talk to the media, even anonymously, because nothing now, everything is up for grabs in Massachusetts. Apparently that's how it works, gang. And it's really scary that you could be just as afraid to speak to the police as, what, now you're going to go to a journalist, sit down for an interview with your attorney present right there? I mean, it's just absolutely crazy to think that there is no privilege, there is no privacy to that. Reed has spoken to multiple media outlets about her case, sometimes in like these sit-down interviews. Prosecutors have requested portions of the content from other media for their case as well. I mean, again, if you go on Reddit, if you go on Twitter, if you go online, there are sleuths that are probably putting in more overtime than your paralegals and are doing it for free. So you could always find stuff on the internet. Nothing is ever deleted. Boston Magazine previously turned over some material from its interview, including audio where off-the-record conversation was redacted. But Judge Beverly Canola Oil said that those redacted materials suggest that the account she gave to Boston Magazine may have differed in certain respects from expected evidence at trial and from other accounts she has given. However, the redactions prevent the Commonwealth from fully understanding the defendant's statements, which is so dumb. It's like, if you knew you were, like, this is what's frustrating. This is what's frustrating, Bev. is the fact that you keep doing this little back and forth runaround. Like, if you know that you're gonna say no, then just say no. Like, what is the point with all these hearings? Every time Karen Reed shows up to court, every single time Alan Jackson's sitting in the chair next to her, every time David Yannetti is sitting in a chair next to her, she is spending money. Money she does not have. It's a waste of her time. It's a waste of taxpayer money time. It's a waste of everybody's freaking time. Is it for the 15 minutes of fame? Like, what are you getting out of all of this? And it's extremely frustrating because, again, it's the same conversation. It's the same freaking conversation that they had back in December. So I want to play a couple of minutes just of his argument because I do think he brings up a couple of good points, again, just from protecting journalism rights altogether and how you're not able to report to the full extent that you want to if you have to give up privileged information from sources, especially when it's off the record. Like, what are you supposed to do now as a journalist? Are you supposed to delete all the notes you've ever had? Are you supposed to burn them into ashes, right? Like, heaven forbid the police come knocking on your door. And I think there needs to be, like I said, more laws in place in Massachusetts and other states where there aren't laws to protect journalists' rights.
Working as agents of the government or the defense. The fourth estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism.
I mean, that is extremely accurate. You know, not that I would reckon Gretchen Voss as a journalist or a serious investigative journalist, but still, I mean, yes, like, just speaking from a high level overview, yeah, absolutely. I mean, it is going to deter a lot of people from digging into the kinds of stories that really need exposing and that are really important for people to find out the truth from if all the government is trying to do is constantly silence those people.
Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this content.
So this is the part that made me laugh, and I think many others laugh as well too. Vitriol. Poor Gretchen Voss. Now, not for nothing, journalists and any content creator, period. I've been warned off of Twitter by people. They're like, don't go on Twitter. It's toxic. It's terrible. And I've definitely seen the vitriol on Twitter for sure. But nevertheless, if you're putting yourself out there on any kind of platform, whether it's a news publication, right? Like Boston Magazine, you're putting your name out there. You're putting your face out there. Gretchen, I'm speaking to you. You're opening yourself up for criticism. It is what it is. It comes with the territory. And if you can't take the heat, girl, get out the kitchen and maybe don't do things like a post or love a post that was made by one of the witnesses in the case that you are talking about in your article. The subject of your article was Karen Reed. This is one of the biggest witnesses in this case, which you are well aware of. And here you are, liking her post. Now, last time I checked, if you're on Facebook, the only way that you can eat, pray, love, whatever, somebody's post is if you either are friends with them or you follow them. Now, I don't know if Jen McCabe's Facebook profile is like set to public where, you can follow her, like she's a business, I don't know, a business, a brand, whatever. I have no idea. I have no interest in looking her up. But I think it's extremely ironic that this happened 2 days ago, that Jen McCabe posted about her apparent best friend / the man who was passed out on the front lawn of her brother-in-law's house, Brian Albert, Officer John O'Keefe. She's posting about the 3rd anniversary of his death. And Gretchen Voss is here, liking it, loving it, hearting it. Like, it just, how tone deaf, how depraved, how out of touch with reality can you both be? And this is 2 days before this hearing was supposed to take place. So it's like, what on earth are you thinking, girlfriend? What on earth? So I do think it's kind of ironic that now she's expressing her fear or her sadness or her anxiety behind the vitriol that she's facing. Like, you're a journalist, girl. You're essentially a content creator. And usually with more criticism means more popularity. Like, that's how it works. So if you're getting a lot of heat, it's also helping to boost your brand. So I don't know what exactly you're complaining about, but it reeks of Jen McCabe for sure. And her whining and moaning and groaning about all the harassment, the poor harassment that her and her family have suffered. Oh my God.
Separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interviews in this case risks putting her again. It mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted.
I mean, why not? It's on Twitter. It's public. So why not?
Her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time.
And like, not for nothing. I mean, we know what that's in relation to, but I mean, it's like people literally have Twitter handles that are Karen is a killer. Like, people talking about her body, like Proctor style, and it's just like, she's innocent until proven guilty, but media by trial says for the very small minority who believe that for whatever reason that she's guilty, there's also a small group of people who are dedicating their daily life to tearing down Karen Reed and creating accounts on Twitter to literally just make fun of her appearance, make fun of her illnesses, what she wears to court. I mean, it's just like such mean girl energy, and not for nothing, you don't see Karen Reed like whining and moaning and groaning about it. Like, you just don't. And again, I'm not saying it's right, but it comes with the territory. If you're putting yourself out there on a public platform and you're choosing to because you're a journalist, then like, hey, you're gonna get weird stuff. I'm not saying it's okay, but like it happens, it comes with the territory. I have gotten, as a very, very micro, small content creator, mind you, I have gotten some weird emails as well too. And I reckon that's because I'm putting myself out there. So it is what it is. Get over it. So that being said, let's get into the actual memorandum. Here it is, yet another loss for Team Commonwealth, shared by Turtle Boy on Twitter X. So this was, I think this was like signed, like this wasn't too, this was only a couple of, 5:47 p.m. So this was probably posted to the docket around probably right before 5 o'clock. So, probably 4 o'clock Eastern. So, pretty fast turnaround time. But again, all of this could have been avoided if you just had like ruled from the first hearing and said, hey, like, I'm not going to play around with these shenanigans, guys. Like, no, I'm just going to say, no, I'm not allowing these redacted notes to come in. Period. End of story. But non-party Gretchen Voss seeks reconsideration of this court's December 5th, 2024 order compelling production of confidential handwritten notes of an off-the-record interview she conducted with Karen Reed. In support of her motion for reconsideration, in addition to her memorandum, Voss filed a second affidavit, and the Massachusetts Newspaper Publishers Association, New England First Amendment Coalition, New England Newspaper and Press Association, and Reporters Committee for Freedom of the Press filed an amicus memorandum. Not to be confused with Atticus Finch from To Kill a Mockingbird. Anyways, squirrel. Given the additional information presented in the aforementioned filings, and after an in-camera review of the handwritten notes at issue, the court has reconsidered its December 5, 2024 order. The court concludes that the content of the off-the-record notes at issue are of a different character than the unredacted recordings of the on-the-record interviews produced pursuant to the court's previous order. Voss has articulated a compelling argument that requiring disclosure of the notes poses a greater risk to the free flow of information than the other materials produced. That's really interesting coming from you, Beverly. Conversely, the Commonwealth has not demonstrated to the court that its need for the handwritten notes separate from the audio recordings outweighs the danger posed to the public interest in the free flow of information. Again, even though Karen Reed's like, release the hounds. Accordingly, the court allows Voss's motion for reconsideration and will not require disclosure of her handwritten notes of the July 7th, 2023 off-the-record interview, dated and signed by yours truly, Beverly Canola Oil. So that, we got one down. Next up, we got the biggin, the house long to die in cold. So the Rick Green Betch stuff. So she, again, made a ruling on this, which I was very, very surprised. Not whether or not she was going to include or exclude Rick Green from testifying at all, but whether or not a Daubert hearing was going to be necessary for that ruling to take place, which, again, I was very shocked by, because we had to do that whole dance, little rodeo, razzle dazzle with Dr. Marie Slade the Day Russell. So I don't know why it's different. Maybe she's just got a personal vendetta against Dr. Marie. I don't know. But Judge Beverly Canola Oil made the ruling after a motion-packed hearing Friday at Norfolk Superior Court, laying out the schedule ahead of Karen Reed's second trial, set to begin April 1st if the case makes it that far. Boston Herald throwing it in there. Reed's defense team has said it's likely it will file motion to dismiss the case, with a hearing on that anticipated action scheduled for February 18th. From my understanding, we're not going to get to it because there's just a lot to unpack. But essentially, at the very end of today's festivities, Alan Jackson was like, yeah, we're just waiting to see what else Hank wants to sneak in and give us. So we're going to wait on that and see from there. see if there's anything else we want to include in that motion. We're still very much putting that together. Special prosecutor Hank BREENAN on Friday requested a hearing to determine whether the defense would be allowed to have computer forensics expert Rick Greenbatch to testify again in the retrial, accusing the computer forensics technician of baseless claims. Methodology. I don't know how many times he mentioned methodology, but I was this close to starting a drinking game. That lacked any evidentiary support. Green testified in the first trial last June that key witness Jennifer McCabe, aka Gretchen Voss' bestie, made the suspicious Google search, "House long to die in cold," hours before Officer John O'Keefe's body was found, which the defense points toward conspiracy. Green's testimony that McCabe's search was at 2:27 a.m., which has been further clarified to 2:27:40 a.m. on January 29th, 2022, differs from that of the state's experts Jessica Hyde and Ian Whiffen, who have said the search was made at 6:24 a.m. McCabe testified that she made the search at the time, saying she did so at the behest of Reed, as the women were near Officer John O'Keefe's body in the snow. There's a man passed out in the snow on the front lawn of 34 Fairview Road in Canton. You know what also I find too ironic about all of this is the fact that Jen McCabe was never once like, yeah, one, it's my friend. He's a Boston police officer. And two, he's on my brother-in-law's front lawn, Brian Albert. You might have heard of him, right? He was in that Mark Wahlberg docu-series, right? Boston's Finest or whatever. So I just find it like completely ironic. None of that information was shared in that 911 call. But anyways, I did not delete that search, she said last May. I did not make that search at 2:27. It sounds like Tommy Wiseau. I did not hit her. I did not. I would not have left John O'Keefe outside to die in the cold because he is my friend who I love. Yeah, okay, sure. So then BREENAN accuses Green of being a vessel for the defense. That's an interesting choice of words because we could say that about pretty much all of your witnesses. Pointing to how first responders testified last spring that Reed was asking them questions about hypothermia around the time Jen McCabe said she made the search. BREENAN also slammed Green's affidavit, which was updated recently, which the prosecutor said was filled with advocacy, insinuations, chemists, conjecture, and claims that have no factual basis. In ways, it's very dangerous affidavit to simply make an assault of comments, the vitriol, the shock, the horror, that a user did something. Because that's what had happened. Out of 4,500, you're telling me, BREENAN, that out of 4,500 searches, one search was deleted. That is not like just a spontaneous like combustion. That doesn't just happen. That exact one, not, oh, how long does it take to deep fry a meatball? Like, it's house long to die in cold on the same night, ironically, that Officer John O'Keefe was found dead. So there's that. Defense attorney Robert Alessi shot back at BREENAN, saying that Green is more than qualified to testify again and use proper methodology. Yes, he pointed out another key finding that Green has made on the search. There were 4,056 searches. Sorry, I thought it was 4,500. 4,056 searches on the phone of Miss McCabe, Alessi said, and his New York came out today. Boy, oh boy, did it, and I was there for it. There was one deletion of 4,056. Guess which one it was? House long to die in cold. There are no odds that can happen. That can happen randomly. Exactly. With those odds, you best be playing the friggin' Powerball. That's all I'm going to say. The defense attorney then pointed to how Green suggested that that could mean there was either a user interaction deletion or post-imaging manipulation of the data. He doesn't accuse individuals. That's the other thing, too. He's not saying, oh, it was Ian Whiffen, or it was Jessica Hyde, or it was Matt McCabe. I don't know. But he says somebody did. Somebody come get her, right? That's the job of a digital forensic person, to point that out and say that raises concerns. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point them out. Exactly. Use the same freaking tools. In fact, he used more. We came to learn he used like 7 different types of tools to do the same thing, including the one that Sir Ian Whiffen, the renowned Celebrite King Poop, created, ArtX, with only 600 users worldwide. Like, it's like, dude created a SaaS, right? He's in the early stages of developing it. You know, if you work with SaaS companies, like it takes a while to get things up and running, and a lot of SaaS companies fail within their first couple of years. But the world-renowned Ian Whiffen definitely knows better than Rick Green, who has been doing this for, 18 years? Or, no, sorry, 25 years? Like, give me a dang break. So now I want to get into a couple of clips that were shared by the lovely Olivia Lambo, again, also on Twitter, because we love people who can do all this fact checking where other people aren't going to, like, clearly. So I thought this was interesting, kind of comparing Ian Whiffen's testimony from trial 1 and aligning it up with exactly what was in Rick Green's affidavit. So, fact check. Here at the first trial, the Commonwealth's own expert witness, Ian Whiffen, confirms the necessity and importance of hash values for the sake of hash verification, a necessary step in authenticating the data and being able to verify that it hasn't been altered or manipulated. In fact, Whiffen actually gives this testimony in response to a question about when the data had been altered or tampered with, if there's a way for the forensic examiner, him, to detect it and or verify its authenticity and integrity. So agreeing with everything that Rick Green said in his affidavit, right? It's very important. Remarkably, despite the DFIR industry standard methodology of hash verifying a digital forensic extraction like that of Jen McCabe's iPhone prior to conducting any analysis on it with any forensic tools, Ian Whiffen testified that notably for his work on this case, not only did he abandon the standard methodology, but he also admitted that the forensic extraction of Jen McCabe's iPhone, which he received from the Commonwealth, was stripped of its hash value. So when he received it, according to him, it was already messed around with. So, and I don't think, I wasn't really under the impression that Ian Whiffen was the one to really tinker around with it too much, but I definitely don't think that he was going out of his way to be like, hey, this something isn't right here, and to like actually do the right thing, because otherwise he wouldn't be able to promote ArtX, right? So perhaps more remarkably, this stunning fact apparently didn't raise any red flags for Ian Whiffen when conducting his analysis in this case, where he's providing testimony in an unaliving trial. One must ask themselves why that is. Again, because he's trying to sell his product, in my opinion. However, defense expert Rick Green in his affidavit states that typically forensic examiners are provided with a raw image file and the associated hash value documentation together. After validating the hash value, I would then accept that the data had not been manipulated. Again, it's like, why would I just get one thing without the other? Like, just give it all to me at once. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. And I love when we read this out in my last video, and I'll link that in my description box, but he says it was withheld from the defense, not just it was withheld from me, it was withheld from the defense. As a forensic examiner, having received hundreds of imaged phones over the course of my decades-long career, this was unprecedented. Contrary to Mr. Whiffin's approach, upon initially receiving a purported extraction of Jen McCabe's iPhone without a hash value to authenticate and verify the integrity of the data, Mr. Green promptly requested the hash value and corresponding gray key supplemental files, which is another thing that he was whining and moaning about today. He was like, oh, he spelled gray key wrong in his affidavit. It's like, bro, you can't even spell your own name right. Like, you're one to frickin' talk. You have grammar and spelling mistakes. You don't even know the difference between bits and bytes and hashtags and hash values. After making this demand, when the Commonwealth had to produce the hash verification data for Jen McCabe's iPhone, remarkably, the Commonwealth also produced for the first time and over a year later on February 8th, 2023, the full file system extraction of Jen McCabe's iPhone. So again, like, why did this come over a year later? And also, why were you emailing him in the middle of the trial? But I digress. As see of Jen McCabe's iPhone, see notice of discovery, yada yada. Unlike the initial purported extraction produced by Trooper Guarino, this one contained Jen McCabe's incriminating 2:27 a.m. Google search and all of the manual deletions of her communications, among other incriminating evidence surrounding the unaliving of Officer John O'Keefe. See Defense's Rule 17 motion from April 12, 2023 attached. So this begs the question, if Ian Whiffen knows the importance of hash verification and validating the authenticity of the data he's working with in the first place, then why didn't he take the same actions as defense expert Richard Green did to responsibly and reliably provide an analysis in this case? If Ian Whiffen ought to be deemed an expert qualified to provide analysis and testimony at trial, then why did he abandon his industry standard methodology of hash verification in this case? Even Celebrate knows this is a no-no. Bang, bang, Olivia, go.
So it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would it essentially hashes the original data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Oh, you don't say.
I didn't have access to the hash information to see whether any changes had been made.
And you didn't have any access to the hash verification data to see if any changes had been made. You don't think that's a little bit of a red flag, not something that, I don't know, you might want to alert to the media? Like,
it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that.
That's that New York coming out right there. Thanks again, Olivia, for sharing this, breaking these clips up. You are doing God's work. So, Olivia Lambo, again, give her a follow on Twitter if you are on the Twitter X. But I just wanted to go over very quickly the affidavit that was signed by Be Still Our Beating Hearts. We actually have an affidavit from Hank BREENAN, but he can't even get his own name right. He can't even spell his own name right, in support of the Commonwealth's response to defendant Karen Reed's motion to recover the expert-related expenses from the Commonwealth, which they did not talk about today. So, my name is Hank BREENAN. I have been appointed special prosecutor, yada yada. Began my appointment in mid-September, so now we have a better timeline of that. I know I had said in previous videos October, but it's mid-September. I learned that the Commonwealth sought and obtained a search warrant for the defendant's phone on February 2nd. I learned that the phone information was provided to the Attorney General's office pursuant to a privilege filtration protocol to ensure that no privileged information was provided or viewed by the Commonwealth. I learned that the Attorney General's office provided reports relative to communications, navigation information, and Google searches. I recently learned that the Attorney General's office did not provide the Commonwealth with the related raw forensic data from the defendant's phone. Now, what's interesting too here is, like, you can tell, like, the font size is completely different. And I think this is on Melanie Little's stream earlier too. She was saying it looks like a lot of this was copy and pasted because some of it doesn't make sense with what the headline is here. Like, what does this have to do with the expert related expenses? And, like, not for nothing, just give her the $12K. Give her the $12K. The woman's already $5 million in debt for a crime she didn't even commit. And you're so stingy about $12K? Like, it's not even your money. It's taxpayer money. And I'm sure a lot of taxpayers in Massachusetts would be thrilled to give that money to Karen Read. Not because they're thrilled of all the shenanigans that you're putting them through and their tax dollars through, but that there would be some level of justice. Because you can bet your bottom dollar at the end of all of this, she's suing the mother duck out of all of you. And it's sad because it's like the ones who get hurt in all of this as well too, aside from Karen Read, obviously, aside from John O'Keefe, aside from his family, are the taxpayers. So after consulting with forensic experts, I believe a comprehensive forensic review of raw data within the scope of the search warrant will provide more information than the report. So Melanie Little did have an interesting theory about this, about the little chip off date that they had in was it in Phoenix? Was it in Arizona last month with the Commonwealth expert as well as the defense's expert to see what they could get from the Lexus, right? The text stream data. If there was anything more that they could get out of it. So her theory, and what other people are speculating on, is if they think they can get some of that navigation data that they wouldn't be able to retrieve from her Lexus, from her phone. Now, what's interesting is, as we know, Karen Read didn't know where the duck she was driving to that night. She didn't know where Brian Albert lived. John O'Keefe was the one to open his Waze app and put in that address. So wouldn't you want to look through his phone for that? And nevertheless, it's like, what does that really prove or give you? Like, I just feel like I'm not 100% sure what more that could provide. But anyways, those are just some of the theories that people have right now. I learned that the defendant's been in possession of the entirety of data, including the raw data from her cell phone since 2022. Although I do not believe my requests involve communications and thus not subject to the communications protocol, I requested that the AG's office engage in a filtration protocol for files I requested, including navigation information. Yes, navigation information and Google information, which is so ironic. What? Because she was looking up DUI lawyers, right? We already said, like, that doesn't prove guilt. You can't use that to prove guilt if you're looking for an attorney. That this request was in an effort to scrupulously protect the defendant's privileges. I informed the defense of my efforts, and the defense advised of its objection. I do not believe the defense has any standing to object. However, after receiving the defense's objection, I contacted the AG's office and asked them to limit the production to files identified by the Commonwealth's forensic examiner as navigation files, because you don't know what they're going to do with it. You can't be trusted, clearly. Based on my conversations with the forensic expert and understanding of what a privileged attorney-client communication consists of, I do not expect any communications to be stored in the navigation files. Upon speaking to the Attorney General's office, it's my understanding that they would, I mean, but again, you can understand their state of concern because Proctor was flicking through her phone, looking for nudes, and came across conversations between her and Yannetti. So I would also be like, hell no, bro. You're not doing that. Like to follow the filtration protocol previously set by the court and by the agreement of the defendant. Commonwealth is seeking clarification so that it can efficiently obtain all the data it's entitled to pursuant in the search warrant and to review the data prior to trial. So there's that affidavit again. Shout out to @suspicioussauce. Give them a follow on Twitter for sharing all of these documents. So yeah, I mean, there's a lot, and then we also have a lot of dates coming up. I did have this saved somewhere. This might be in my document. So this is, again, also shout out to Suspicious Sauce. So this is what we can expect for the rest of February. February 5, February 6, 11, Valentine's Day, the 18th, 21st, then March. That's like all pretrial stuff, right? We're really getting into the nitty gritty of all of this. There is going to be no, like I said, Daubert hearing of Richard Green. I think that she's ultimately going to allow him to testify again. Why wouldn't she? She would look like a goddamn fool, but it's Beverly canola oil, so anything is possible, right? Miracles happen once in a while. Maybe she'll just come to her senses and say, hey, not doing this again. Or maybe the SJC will finally provide its ruling. I mean, they have to, right? Like, weren't they due to, like, come back, like, last month or 2 months ago with it? And here we are, still in limbo. So I can't even imagine what it's like to be Karen Reed. And, you know, I hope that she just keeps pressing on, keeps on keeping on. She looked great today. She looked, you know, pretty, I don't know, like, pretty positive. She usually does. So hoping all the best on that end. And with that being said, thanks to all of you for continuing to tune in. I got some really lovely messages from you guys who followed me on Twitter today. So yeah, if you want to join the party, somebody, all right, so you won't be 101 because somebody already slid into that spot, but you will be 102. So if you want to be my 102nd follower on the Twitter X's, please go head over to @AlexisRoom. I'm going to try and post there a few times a day, just kind of reacting to certain stories, certain things in the news, maybe stuff that I'm not always covering on the channel, because it's a lot of work to put together these videos. And as you know, I have a day job, so it's, you know, I can't cover everything, but it's a great way to interact with me and get me to answer your comments, questions, etc. a lot faster. So join the party over there. We're keeping it cool. We're keeping it classy. And with that being said, if you enjoyed today's video, make sure you hit that subscribe button. Make sure you hit the notification bell. And make sure you hit that like button, because that tells the YouTube algorithm that Beverly, you better get your crab legs together, because we're not doing this. We're not doing this again. We're just not. We're not doing it. So that being said, thanks for tuning in. See you in the next one.